So, DeDe, welcome. Today, we are going to cover trust administration and try to give a step by step guide for trustees, people who knew they are going to be a trustee, or maybe people even that have been surprised and just found out they have to be a trustee. So, first, for someone who's just been named a trustee, maybe could you talk about what does it actually mean to be a trustee, and then what is trust administration?
Okay, that's a loaded
The big one,
question.
yeah.
I will say that, right? What is a trustee? So, a trustee holds a fiduciary title. And I always say when you're alive, you are the grantor, which you are the owner of all your assets that you have put into the trust. And then you are also the trustee of those assets. That means you're the manager. I always like to say you should have two hats, one that says owner and one that says manager. And as a trustee, you are the manager. And that means you actually have a fiduciary duty to manage the assets in the trust for the benefit of the beneficiaries, right? So it is, you cannot. So if you're alive, it's kind of two different duties, if you will. But once somebody has passed and there's a successor trustee stepping in, that's when there's this higher fiduciary duty. You have a duty to make an act to act for the benefit of the beneficiaries. You cannot commingle some things that seem quite obvious. Some people think, oh, well, I'm the trustee. I can do whatever I want, right? Well, yes, you are in control, but you have a higher duty to make sure you're not commingling, to make sure you're acting on the best on behalf of all of the beneficiaries, right? And that's where sometimes people will be a trustee and they're also a beneficiary. So I always tell people we're representing you as the trustee, not you as the beneficiary. So they have to draw a land in the sand for sure because they can't act in their own best interest. And a lot of trustees do. And that's when they get into trouble. So there's a lot of liability on the trustee, but you're managing the assets, you're acting on behalf of the beneficiaries. So, sort of that's the overview of what trust administration is, right? Someone has passed and now they have this trust, and there's rules to follow within the trust. And it says who's going to get the assets, but it's really managing it for the benefit of the beneficiaries.
How important is it for the trustee to really review the trust carefully before taking any action, and maybe give some examples of something that could happen if they don't do that correctly?
Right. So a lot of times, well, if you don't read the trust, you're not going to know what's going on, right? And you could just say, "Oh, I know they have a house. I'm just going to list the house and sell the house, and then I'm going to distribute the beneficiaries the money." Right? Everyone always just wants the money, but maybe there was a specific distribution in the trust. Maybe the son or the daughter is going to get the house. And so here in California, there's a notice that has to be filed within 30 to 60 days. You need to send notice to all the beneficiaries, and they have 120 days to contest the trust. So if they were a beneficiary, they can come forward, they can file a lawsuit and say, you know what? I was supposed to get the house. I had a promise, or I'm supposed to have 75%. And my siblings only supposed to have 25%, or I was a child that was forgotten. They didn't name me in the trust, or I was disinherited. So you have that 120 days to actually file a lawsuit. And so the trustee has to be very careful when they send out notice. It's, to the heirs and it's to the beneficiaries of the trust. And so then if they don't send a copy of the trust with that notice, then a beneficiary can actually call the trustee and say, I want a copy of the trust. I'm entitled to it. I'm a beneficiary or I'm an heir and I want to read it. Right.
Okay.
So there's two. Yeah. You can either send a copy with this notice or not. But this notice is very important because if
So,
you
yeah.
don't send the notice out, 6 months later, the trustee could say, oh, I'm distributing everything. And then all of a sudden there's an heir that says, wait a minute, I never got notice. And then they can sue and bring a cause of action against the trustee for improperly administering the trust.
what's the most effective way that a trustee can identify and take control of the assets, and maybe list a few of the types of assets that are commonly involved?
Absolutely. So if a grantor has passed and now the successor trustee is stepping in, they give us a call and they're like, there's bank accounts, there's brokerage accounts, right? So they need what's called here in California, they need what's called a certificate of trust, where the certificate of trust that is signed by the successor trustee and it's notarized and it says who they are, right? And the name of the trust. Now it's the successor trustee of the Soto family trust, right? So then they take that certificate of trust, which matches the trust, the actual trust document that says they were appointed. They go to the bank, and with that certificate of trust, then now the bank account will actually be in the name of the trust with the successor trustee's name as the manager, right? So they have to actually physically, and then the account gets changed over to this trust, and of which the trustee has also gotten a tax identification number, right? Because you cannot use the social security number to open up these accounts of the person that has passed, right? So it's a new EIN number for the brokerage accounts, for the bank accounts, savings accounts. Even if there's a life insurance policy, they have to pay the life insurance policy. If it's payable to the trust, then they would use the new tax identification number and the certificate of trust to gain those assets. If it's real property, they actually change the title of the real property to their name as successor trustee. That doesn't mean that they own that property, but they're managing it on behalf of the beneficiaries.
Okay. And you mentioned in terms of debts, expenses, and taxes and things like
Mhm.
that, that the trustee is responsible for, and maybe should wait to distribute before they until they know all of those things. Um,
Correct.
so how do you think a trustee should think about that in terms of trust administration? How they should wait, and how to identify those things, and then and maybe even talk in a little more detail about handling taxes and that process during
So
the trust
no,
administration.
yeah, certainly. And, a lot of times people will call us and say, we're the trustees. We got to get started. And, maybe someone just passed within a very short period of time. And so we always say, you got to get the death certificate, right? You can't, in California, you cannot pass assets unless 40 days have passed. So even if you were to get the death certificate, you cannot transfer assets for at least 40 days. And so in doing so, there's sort of a, 30-day, 60 days, 90 days, a year. And we usually tell our clients it's going to take a good year, right? So if someone passed in March of this year, you can't file the tax return until next year, right? So that's where you need to hold back the money so that you can do their final personal tax return, and then you can do, obviously, you'll have to do a trust tax return on an annual basis until the trust is distributed. Or sometimes the trust will be broken down into sub-trusts for various different beneficiaries, and it's that asset protection. And so you will continue to file the tax return on the trust and until the beneficiary is able to step in and take the trustee responsibility of their own trust.
So when do you recommend that a trustee actually bring in a trust administration attorney? And are there some signs that that may indicate that trust administration is going to be more complex than it
Complicated.
first appears?
Yes. Well, if you have a disgruntled beneficiary, right? Absolutely, you should give us a call from the beginning. If the trust is not so good, right? And you can see discrepancies in the trust, you should probably give us a call. If you can't locate assets, or if there's assets that are not in the trust, right? Many times it's like, oh, the house is not in the trust, or their bank accounts, or, then you have to open up probate. So these are some, I would say, red flags right away. If it's a blended family, you definitely want to cross your T's, dot your I's, because that's probably, one of the number one litigated trust issues is with, you know, blended families, because one passes and they want to make sure that their share is going to be preserved, even if there's a good relationship with the surviving spouse, right? You don't want the surviving spouse just to, spend it on whatever they want unless the trust says they can, right? So it's like they can go through their bucket, the marital bucket and the family bucket, but many times they cannot go through the family bucket.
Mhm.
So I think at blended families, if there's a large asset, large assets, I think you don't want that responsibility because you could be personally liable. It could be embezzlement, it could be fraud, you could be personally liable. They could be going after your assets if you've mismanaged these assets. So, of course, I know I'm an attorney, but I think this is one area where you really want to seek guidance.